Assalamualaikum and hi. My name is Alia Darwisha binti Muhammad Shajairi. My matric number 04DAT23F1013. I would like to present our presentation company law. This is our team.
Question 1. Susie, a member of Orlando SDMHD, the company, uh, wishes to petition for winding up the company on the grounds that it is just and equitable to do so. She seeks your advice as to a situation in which the courts would likely grant such an order. Explain to Susie with reference decide cases. Issue for this problem is whether Susie, a member of Orlando SDMHD, can petition uh, for a winding up of the company on the grounds that it is just and equitable to do so under law. Principle of law, uh, section 4C5 bracket 1 bracket H. A. The company pass a special resolution that the company is to be wound up by the court. B. The company does not commence business within a year from the day of incorporation or the business has been suspended for a while years. C. There is no member in company. For the relevant case for this problem is Loss versus John Blackwood Ltd 1924 AC 783. The court allowed the company to be wound out because the director failed to hold meetings and present company account indicating a loss of trust. For application, in Susie's situation, if she can prove that there is a prolonged internal conflict that cannot be resolved, as in Yanish, she can be excluded from her rightful role in management, uh, as in Ibrahim, or the directors or majority shareholders abusing their powers or ignoring the interests of the minority as in lodge. Then the court may consider granting a winding up order under the just and equitable principle.
In conclusion, Susie may petition to wind up the company under the just equitable ground. However, success depends on proving that the situation is severe enough to justify such an order. Question 2. Differences between compulsory winding up and voluntary winding up. For compulsory winding up under Section 464, Subsection 1, Clause A, by presentation of a petition in the court, reasons. Section 465, Subsection 1, Clause A, the company passed a special resolution that the company is to be wound up by the court. Section 465, Subsection 1, Clause B, the company defaults in lodging the statutory declaration under Section 190, Subsection 3. Section 465, Subsection 1, Clause C, the company does not commence business within a year from its incorporation or suspends its business for a whole year. For voluntary winding up under Section 432, Subsection 2, Clause A, by a member's voluntary winding up where the company is solvent and the liquidator is appointed by the members at the members' meeting. Under Section 432, Subsection 2, Clause B, by a creditor's voluntary winding up where the company is insolvent and the liquidator is appointed by the creditors at the creditors' meeting. Section 465, Subsection 1, Clause D, there is no member in company. Section 465, Subsection 1, Clause E, a company is unable to pay its debts. Section 465, subsection 1, clause F, the directors act for own interest. Section 465, subsection 1, clause G, the company expires. Section 465, subsection 1, clause H, the court decision for the company to be wound up. For voluntary winding up reasons, Section 439, subsection 1, clause A, the expiry of the period fixed by the Constitution or the occurrence of events provided by the Constitution that the company is to be dissolved. Section 439, subsection 1, clause B, the company has passed a special resolution in a general meeting for the company to be wound up. Categories: Section 432, subsection 2, members voluntary winding up and creditors voluntary winding up. That's all from us. Thank you.